Paul, are we ready? Okay. All right, my watch says 6 o'clock, so we'll go ahead and commence with this public meeting. Appreciate you guys taking the time out of your busy schedules. Can everyone hear me? I'll try to speak up a little bit. Taking time out of your busy schedule to come to this meeting. I do want to make it clear up front that although you received a summons in the mail, that summons does not require you to attend this meeting. I know that can be a little confusing. That's just one of those statutory things we've got to do, and I understand that can be kind of intimidating. So right up front, not required to be here. You can leave at any time. And if at any time you feel like this does not pertain to your situation, feel free to stand up, walk out. You won't hurt my feel bads. I understand we all got busy lives and things to do. So my name is Blake Bingham. I am the Assistant State Engineer for the Adjudication section for the Division of Water Rights. This is the public meeting for the Dry Creek Subdivision of the Utah Lake Jordan River General Adjudication. Now, I'll go into depth as to what that is and what that means. I'm sure there are a lot of questions. Obviously, generally when we have these initial public meetings, many people attend just out of curiosity. Some are worried that this has to do with maybe their municipal water connection. That's not the case. Before I do get started, I do want to just recognize we have the Deputy State Engineer, Boyd Clayton, here in the back in the white shirt, as well as you met members of my team, some of my staff. They will be on hand following this presentation to answer questions you have. Following the presentation, we'll also have some maps out in the hallway that you can look at a little bit closer, maybe identify your lot or your property within the subdivision boundary and see if there's any. We've also plotted on that map points of diversion, such as wells that may be applicable that you can kind of key in and see if maybe it does affect your property or not. Also, this public meeting is being recorded, will be available on YouTube. There's a link on that on our division website if you're interested to go back and review what was covered tonight. Or if you have a hard time seeing these monitors, you can look at that presentation and maybe get a better idea of some of the material being presented. So with that introduction, let's go ahead and kick her off. Here's the agenda. We'll discuss the general adjudication process, also discuss what a proposed determination is, some of the significant issues and the timelines we anticipate, and then we'll answer any questions. Now, honestly, if you have questions throughout the presentation, as long as they're kind of general based and for the good of the group, I have no qualms in answering those questions. But if we start to kind of keyhole in on situations that only pertain to yourself, I might ask you to just kind of hold off, and I'll stand and we can answer those questions offline following the presentation, just to ensure that everyone's time is taken care of. All right, so let's start off with Water Rights 101, shall we? What is a water right? Well, unlike your municipal connection, a water right is generally, it's the right to divert water in the state of Utah, and it's kind of associated with a couple different variables. You have a defined nature of beneficial use, and that means what is the water right being used for? Is it being used for irrigation? Is it being used for domestic residents? Is it being used for stock watering? So those are, when we talk about nature of beneficial use, those are the type of variables we're discussing. It has a priority date, which means generally is associated with the date that the water right was appropriated, and that ties into what priority it falls in the distribution among other water rights. And we'll talk a little bit more about that later. Has a defined quantity, and we define that by a diversion flow rate, either in cubic feet per second, or CFS is the acronym, or by an annual volume, an acre foot. If you can imagine a field that's an acre in dimension and 1 foot deep, that's how much water would be associated with an acre foot. It has an associated point of diversion. For this area, those points of diversion are generally speaking wells or they might also be consist of head gates off of streams or spring boxes. I think there's an area in the Gilmore Park, I want to say, that has a bunch of springs associated with it. And it's a place of beneficial use, and that's essentially where is the water right being used. Okay, so here are some things that may be evidence of a water right. It's not a comprehensive list, but generally you might have a well. See the pictures on either side. Those are of well heads, kind of domestic, small wells. Or you might have a head gate on a stream, and that's kind of a little bit more easy to identify. There might be irrigation ditches and those types of things. So what a water right is not. It's not a share in an irrigation company. I'm not sure that there are any irrigation companies in this neck of the woods of Salt Lake, so we don't really spend a whole lot of time delineating that. But it's not a connection to a public water supplier. It's not what you pay your monthly bill to Salt Lake Public Utilities. It's not that, okay? Now, Salt Lake Public Utilities do have water rights, but they are responsible for responding to this and pursuing their claims with respect to this general adjudication. You simply just got to keep paying your bill. That's your obligation. So when we talk about general adjudication and why we're doing it, it's hard to not bring up some historical context. So if you'll bear with me a little bit, we're going to discuss some of the early history of Utah, how water rights became kind of evolved, and why we currently do general adjudication. So we'll start off with kind of the pioneer era, and we all know the story. In 1847, Brigham Young entered the valley, said this is the place, and the next day they started diverting waters from City Creek to soften up the soil and to allow for crops to be planted, kind of a late season crop. They later built their shopping mall there. Sorry, these are old jokes to a lot of my staff, but in 1848, Brigham Young kind of made a statement, and it kind of shaped the way that water would be distributed in the state of Utah from there forward. He said, "There shall be no private ownership of the streams that come out of the canyons. These belong to the people, all the people." And so still today, water is owned by the public. It's not owned by the state. It's in the Utah statute that the waters of Utah are owned by the public, and they're appropriated. Now, we try to manage those, but in the end of the day, they're owned by the people. Well, as you can imagine, from 1847 to 1850, what we now know as Utah kind of went from being a part of Mexico to this kind of quasi-ecclesiastical state of Deseret to the territory of Utah. However, the government remained church-centric, and that's just a matter of fact. That was kind of the power that filled the power vacuum at the time. As a result of that, diversions from the streams were kind of formed on a communal basis to meet the immediate needs of the settlers. The doctrine of priority, remember I talked about priority date. Well, the doctrine of priority was established through the recognition of groups of people who first settled the area, maybe built these ditches, built these diversions, and then recognized secondary settlers coming in. So you have this concept of primary rights and secondary rights, and that kind of evolved along with the mining doctrine of first in time, first in right. So you have these two types of systems evolving simultaneously in Utah. Conflicts were settled through ecclesiastical channels. You had bishops' courts for local disputes, and you had the stake high councils, which kind of served as these appellate courts that would resolve the issue if they didn't like what the bishop had to say. Well, as we kind of transfer into the territorial era, in 1852, the first territorial legislative assembly attempted to, move the power structure from the LDS Church in kind of more an organized fashion, and they gave the county court the right to distribute timber and water. However, that was really only followed in Salt Lake County. Most of the rest of the state kind of largely ignored that. In 1877, the Desert Land Act was passed, and that was in an effort to reclaim the arid West. Part of the result of that act is that it severed title of the water from the ground, and it also delegated the authority for the administration of water to the respective territory or state. And we kind of look back on that as a foregone conclusion, but if you think of it, the government land office owned by the GLO, owned by the federal government, administered land, so you would almost think, well, it makes sense for them to do the same thing with water. Well, this act effectively established that states would be responsible for administering water and doling out the rights associated with it. In 1880, there was a failure to enforce that first 1852 act, so they tried to appoint these county selectmen to administer water rights, but it's found unconstitutional. And again, few counties followed it. As a result of this era, confusion over existing water rights continued in spite of the best efforts of the territorial legislative assembly, as well as the church. And the church continued to administer and decree water rights. I often cite this example that in 1879, there was a church high council decree on the Spanish Fork River, which is largely in place to this day. There's been subsequent decrees to kind of firm that in place, but the church high council decision was the initial forming of how those waters were first distributed. I promise I'm getting to the point of adjudication. Just bear with me a little bit longer here. Well, in 1896, we know Utah became a state, and there was some real concern over the fact that, or there's some discussion, some controversy that as part of this new state, that maybe the state would come in and confiscate all the water rights. And so there's some controversy among different groups, and so they decided, well, what we're going to do is we're just going to table the concept of water rights altogether. We're going to say one thing about it in our Constitution, and that was all existing rights to the use of any of the waters in this state for any useful or beneficial purpose are hereby recognized and confirmed. So in essence, if you had been using water up to that point, your rights to use water were confirmed moving forward. Okay, and that was all they said. They said it's too controversial. We're not going to touch it at this time, but we'll do that. Well, in 1897, the Office of the State Engineer, or what we now know as the Division of Water Rights, was formed. But the state engineer was primarily concerned or given the task for conducting hydrographic surveys, in essence, mapping out streams and rivers throughout Utah to see what use or ability for irrigation, other uses would be. Appropriations were still kind of done in the old-fashioned way. When I say appropriations, I mean acquiring new water rights were still kind of done the old-fashioned way, where you'd go get your claim and you bang it in at your point of diversion, then you'd go post it at the post office and record it at the county recorder. And so, again, that was largely ignored. In essence, if you were living in Cedar City and you wanted to divert water, you just go divert water. And if you had a conflict, you go to the church and they'd settle it with the other ward members. Well, in 1902, the United States Reclamation Service, what we now know as the Bureau of Reclamation, was formed, and they were, their mission was to reclaim the arid West, right, to allow for irrigation and settlement of the West. Well, as part of that, their task, their mandate to build these large water projects, huge reservoirs, and they were reluctant to do that anywhere in the West until that respective state or territory had a comprehensive water law for determining what the existing rights were. And so, as you can imagine, Utah wanting to kind of get in on this act. In 1903, they decided to go ahead and pass a comprehensive water law because they wanted to reap the benefits of the Bureau of Reclamation's projects. And so they passed the law. It called for the recording of all these existing rights. Remember, the pioneers had been using water since 1847 forward, and we're in 1903. So there are all these uses of water that had been occurring without any kind of recording. Well, this provided the framework for it, and then the adjudicating of those rights. So taking those rights, recording them, and then taking them to the court and having the court settle the issues. Since they're property rights, they had to go through the courts. Well, the legislature unfortunately failed to give any funding to the courts, and so really nothing happened. Well, in 1919, the statute was kind of summarily changed, and this is roughly how we do it today. They gave the state engineer the responsibility for doing an audit of the water rights in these different drainages and preparing a proposed determination or a determination of the water rights, and then giving that to the court. And that made the court's job easy, because now you have the state engineer giving his best recommendation to the court, and then the court says, unless someone objects to it, this is how we're going to distribute the waters. And in 1935, groundwater became a part of the Utah water law, comprehensive water law. So prior to 1935, you didn't need a water right to have a well. After 1935, it joined a part of the appropriation system. A similar thing can be said of surface water rights. Prior to 1903, you didn't need a water right. After 1903, you needed to acquire one. So why did prior to the enactment of the comprehensive Utah water law, the water rights kind of fell into 5 different categories. You had those rights that were decreed by ecclesiastical leaders, those that were filed for record at the county court, those that were decreed by a court, typically involving limited parties, and then contracts or agreements that amended that were among limited parties. And then finally, you had those rights that just no one ever found. You know, if you were diverting water and you were up in the hills of Utah and no one really had a controversy with it, you just continued to do what you were going to do. So consequently, as a result of this, a lack of a definitive water law, it created a number of issues. First, there was no public record. Because there was no public record, over-appropriation was rampant. And because rights weren't defined and over-appropriation was rampant, there was a lot of controversy among water users taking each other to court. So in his biennial report for the 1901-1902, for his biennial report during that period of time, the state engineer made the following observation. He said, "The definition of existing rights appears to be of first importance. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made a public record." So his thought was, hey, we're going to adjudicate everything and then we'll start appropriating water rights. Unfortunately, it didn't work out that way. We decided to kind of go down the path simultaneously. And so we started adjudicating rights, but the state engineer also started allowing people to appropriate new rights. And so here we have the general adjudication in its present form, where it considers all of those rights. So what is a general stream adjudication? As I kind of implied earlier, it's an action in state district court. It binds all water users, including the state engineer, aka the Division of Water Rights. That's the title and section, or title and chapter of code that it's governed by. Title 73, Chapter 4, if you can't read that. And the first general stream adjudications took place in the 20s. Among those that were first conducted were the Sevier and the Weber and the Virgin River, and those have since been completed. The general adjudication that we're talking about now is that purple one, that purple blob in the middle there, the Utah Lake Jordan River general adjudication. And that actually started in 1936 by a private lawsuit, which was then transferred by the court into this general comprehensive adjudication. So why do we conduct general adjudications? Well, we want to bring all the claims on the permanent records. You remember those guys that were using water prior to 1903 or prior to 1935? We want them to file their claims so we can get them on the permanent record. So we call those pre-statutory claims. And then there's also these things called Federal Reserve rights. In essence, the long story short, there was a court case involving an Indian tribe. They were attempting to secure water rights for their reservation. However, the state had appropriated all the water rights around it, and they didn't have any basis for an appropriation in that state. So they took them to court. The Supreme Court ruled that by virtue of the fact that Congress had reserved that Indian reservation, there was an implied water right created by it. That same case precedent has been used to establish Federal Reserve rights in other reservations, such as national park reservations, Forest Service reservations, military reservations. So this is the same. But the general adjudication, thanks to the McCarran Amendment, is the only thing that can bind the federal government and to quantify those Federal Reserve water rights. I can go on for ages about that, but I'm not going to. Interesting topic, though. Also, we want to prevent a multiplicity of suits. We don't want people suing each other all over the place. We just kind of want to get a picture of the water rights at that time and settle those issues. And we want to remove or reduce water rights which have been abandoned or forfeited out of non-use. So in Utah, actually throughout the western United States, there's a concept, it's kind of a use it or lose it concept with water. And it's really designed to ensure that water is being beneficially used, that people aren't monopolizing it or speculating on it. And so if in Utah, if you don't use a water right for 7 years, then it can be forfeited and returned back to the public for appropriation or to satisfy senior rights. And so that's one of the kind of sticky things is if you have a water right and you haven't used it, there's a potential for that issue to come up. And then finally, we want to obtain do we have a question now? her question is, what does using a water right mean? It means simply putting it to the beneficial use for which it was first appropriated. So if you got a water right for irrigation, it means using it to irrigate your lawn or your crops, those type of things. So, and then in beneficial use of a water right, in Utah, we often like to quantify water in cubic feet per second or acre feet. But in truth, Utah water law is based on beneficial use, and beneficial use is the basis, limit, and measure of a water right. So that's why when we look at a water right, we're looking for what it's being used for, and that's why that's kind of the thing, because rather than how many acre feet or cubic feet per second, we're more interested in what it's being used for. Lastly, we just want to obtain final comprehensive decrees on all water rights within the respective drainage. So here's the adjudication process, and it's kind of a three-phased process. This initial phase culminates with what we're doing tonight, the public meeting. We had the petition, and actually it wasn't a petition. This is back in 1936 when the court transferred the case to a general adjudication. The notice was sent out. It was actually published in the newspaper, and the summons is what you received in the mail the other day. That probably scared you a little bit, or maybe it didn't scare you. It would scare me. As well as is published in the newspaper. And then tonight we're having the public meeting. So we're at step 4 right now. The next step, and I'll dig into these a little bit in more detail here shortly, we'll have the notice to file claims. So we'll send you a notice, and you'll have an opportunity to file claims for water rights which you are asserting. We publish a list of unclaimed rights. That means in our office we have files of water rights that are on our records. And if those water rights that are within this respective drainage don't get filed on, they go on this list of unclaimed rights. Then there's a 90-day period to object to that list of unclaimed rights. So if you had one of those rights and we put it on there and you say, hey, I don't want you to put that on there, then that'd be your opportunity to object. Have another public meeting, resolve any objections there would be, and then have a court decree on that list of unclaimed rights, which would in essence declare those rights abandoned. Following that, those claims that are filed, we would go out and evaluate. We'd review in the field. We'd contact you guys and come out and look at them. And then the state engineer would make his recommendation in what we call a proposed determination, or a PD. That's step 11. Again, there's a 90-day objection period where people who don't like that proposed determination can object. We have another public meeting. And then we have this final summons just to make sure we didn't miss anyone, and then hopefully get an interlocutory decree on this subdivision within the Utah Lake Jordan River drainage. But let's get into the weeds a little bit more. So I talked about the notice to submit claims. So in the next few weeks, if you receive the notice tonight, and those individuals who came up and gave me their email addresses will get you added to this list, you'll receive a notice to file your claims. And that's your official notice to make a claim for any water rights you want to assert. For those that are an owner of a water right on our records, you'll receive a water user's claim that's already filled out, and you can simply edit it and sign and return. Or if you're a property owner, and let me give you a little context there, we sent notices out to all the property owners within this area. So that was some 8,500 notices to separate entities that went out. And we have on our records about 34 water rights. So the possibility of you guys owning a water right, it's pretty small, right? It's less than 1%, probably, a fraction of 1%. So just keep that in mind, just for some context. To file a water user's claim, so you have 90 days to file this claim. If you know, and it's not impossible. Certainly there are areas where people have had wells in place prior to 1935 and just never had a water right brought under record. So it's not unheard of. So if you fall in those situations, submit your claims. So once you receive that notice, you have 90 days to file your claim. You can file it with us, the state engineer's office, or you can file it with the court. It's up to you. But just make sure you file it before that 90-day expires. Now, if you need a little bit more time, you can petition me or the state engineer in writing for a 30-day extension, and that's something I can grant. After that, it's up to the court, and you have to take it to the court in order to get any more extensions. Sure. So our question is, do you have to pay legal fees to file a water right? No. You can file it for free here, and you can file it for free at the court, I want to say. Now, if you want an attorney to prepare your water user's claim, you're going to have to pay the attorney. But I'll say right now, if you come in and say, I want to file a claim, we'll help you prepare the claim. We'll take you through it, because it's not super intuitive. We understand it's daunting and a task. So I would encourage you to schedule time to come in and have one of my staff help you fill out these claims if you want to assert a water right. Too easy. Once we receive the claim, my staff will go out and evaluate it. And so this is one of those things, if sometimes we get people who are simply banking on the fact that we won't ever check up on them, because we know water is money, right? And so occasionally there's the speculator who wants to say, oh, well, I have a water right, but it's buried under my driveway, so you can't see it. I'm totally using it. So we will come out and investigate or assess the claim that you file. So just make sure when you're filing that claim that you're not wasting your time or our time if you can. Let's make sure that it's a legitimate claim, because we will come out and investigate it, and then we'll map it. You recall the list of unclaimed rights. Well, as I mentioned, those 34 water rights that we know of that are in this boundary, those are what we call water rights of record, meaning we have records of those. If there are any of those don't receive a claim filed on it, they get compiled into this list of unclaimed rights. In essence, what happens then is that list of unclaimed rights gets published, and when I say published, we essentially publish it in PDF and put it on our website and file it with the court, and then we send out notice to everyone here that, hey, it's published and this is where you can access it. And we'll give you a little URL or a hyperlink where you can access it online, or you can come in and look at it in person. And what the list of unclaimed rights is that it's saying no one filed a claim on these rights. And so people have 90 days to object to that list. Otherwise, what happens? And so let me back up. To object, you need to file your objection with the court. This is one of those things where you don't file it with the state engineer. This is a legal proceeding, so you need to file the objection with the court, and also file your water user claim with the objection saying, I object, this right shouldn't be on the list of unclaimed rights. Here's my water user's claim for it. And then you're supposed to give a copy of that water user's claim to the state engineer at that time. Again, we can talk more in detail about it if you have any questions on that. Once an objection is filed, we've got to resolve it. Either it gets dismissed by the court or we negotiate a settlement. Generally, for the list of unclaimed rights, we're just going to say, file your claim, and then we'll evaluate it. We don't really don't fight these very hard, as long as you have a legitimate excuse. And then the judge will issue a decree once that 90 days has expired, that objection period, and we've resolved any objections that may or may not have been filed. The judge will issue a decree asserting that all of those rights that were in that list of unclaimed rights are abandoned. And that means they're gone, meaning they're no longer valid rights. So we want to make sure that everyone gets notice of this so that rights are not abandoned without notice of people who have vested interest in those rights. Following the list of unclaimed rights, we publish what's called a proposed determination. You recall we went out and we evaluated these claims. Now we take that evaluation and we kind of come up, well, it appears that they filed for this many acres of irrigation. When we went out to the field and we mapped it, they really have this many. And so we make a recommendation to the court and put it in the proposed determination. The proposed determination is the state engineer's official recommendation to the court as to how we think the water rights should look like within that respective subdivision. Similar to the list of unclaimed rights, we send out notices to everyone that filed a claim, and then we'll have another public meeting to discuss or answer any questions. Again, people have 90 days to object. If they don't like the recommendation the state engineer's made, they file an objection with the court. We have to resolve the objection one way or another. That doesn't mean we have to capitulate, but often we try to negotiate a settlement, make sure that, hey, if we're wrong, we'll gladly admit it and we'll make an amendment. If we're not, we might end up litigating it and take it before the court. But anyways, those have to be resolved before the court can finally enter in a decree for that area. Now, the decree, I'm just going to back up really quick. I forgot to mention, so you recall the list of unclaimed rights. As part of that decree, what that does that decree seals off anyone from asserting a pre-statutory right from there forward. So you're going to need to make sure if you're going to file a claim, or if some of you are more familiar with the water rights terminology, a diligence claim or an underground water claim, you need to do it prior when you receive that notice, because that judge is going to issue that decree, and he's probably going to close the basin to any additional pre-statutory assertions moving forward. All right, so I'm jumping back to the end of the proposed determination. In the early days, you had one giant proposed determination for the entire drainage. We've quickly realized that's untenable. Just in this small little Dry Creek drainage, like I said, we have 8,500 people that we sent notices to. So we can imagine what the entire Utah Lake Jordan River drainage how difficult that would be to actually go through that and make it through in time. We try to get these interlocutory decrees or partial decrees, meaning we're gonna take a bite-sized decree out of this basin, one bite at a time, right? And that's kind of why we're kind of working our way. We just did City Creek, now we're into Dry Creek, and then we're going to continue on moving south. Federal Reserve rights, I've kind of already discussed that. And then, as I mentioned, decrees often include language closing the respective basin from diligence claims or pre-statutory rights. So here's the Dry Creek proposed, and it's a City Creek up there, that's a typo. Dry Creek proposed determination boundary. It's kind of hard to see on these small monitors, but if you have that FAQ, and we'll have some bigger maps after the meeting where you can actually see this, but if you see that those clusters of green, those represent those water rights that we have a record of. That's where those points of diversion are. Again, you'll be able to get a better look at those maps in the hallway after this. The total area of this adjudication is about 5,700 acres. We have 34 water rights that were of record. Most of them are underground wells. Let me see. Oh, and I said we have 8,500 property owners that we've sent notice out. You see all these different colored areas. Those are the other general adjudications. So we're just talking about that pink one in the middle is the Utah Lake Jordan River. And that stretches all the way down to Nephi and up into Heber. So it's a pretty large drainage, and this is just one bite of it. Okay, issues and anticipated timeline. So I mentioned those water rights of record. Often what happens is people come and go. Some of these wells are associated with homes, and the new homeowner acquires title to the water right just by virtue of acquiring title to the home and the but they fail to update that information with the state engineer's office. So often when we send out notices to these water right owners of record, it's addressed to the old owner. And so we encourage people, if they have a water right of record, to update title with us. There's a separate process, and we can point you in the right direction of how to do that. And that will get your updated address with us, and we can move forward. Also, some of these water rights are what we call no proof required. During the World War II, there was a lack of engineers around who would do proofs, and a proof is in essence proving up on your water right appropriation, saying, hey, I've appropriated this, I'm putting it into beneficial use, this is exactly where it is, this is where it's being used, and then you submit that to the state engineer. Well, there was a time in period where that wasn't required just because there weren't enough civil engineers or surveyors to do that. And so a lot of these water rights, they might have a location. You might see the little dot on the map, but you got to kind of take that with a grain of salt because that's never been surveyed in or verified by a professional. So some of those points, although it might say, hey, the well is right here and it's located in the middle of my backyard, well, in truth, it might be several hundred feet off of that, because when they appropriated it, they simply said, yeah, this is roughly the location where my well is going to be, and then they never had to file proof. So I'm just saying, be conscious of that. Yes, sir.
Is it possible that one of these rights is in the hands of an association that then distributes?
So the question is it possible that one of these rights is in the hands of an association that then distributes? Well, yes. As a matter of fact, I know some of these rights are in the hands of Salt Lake Public Utilities, and then they distribute water to their clientele, right? And so in that sense, it is possible. Often what you see, so you have public water suppliers where that happens. You also have irrigation companies where that happens, where they have the water rights and they sell shares of their stock to irrigators who then use it to irrigate their cornfields or alfalfa fields. So it is a scenario that's possible. I believe Salt Lake Public Utilities does own some of these rights in this area. I have to look at it a little bit more closely, though. Anticipated timeline. The notice to file claims will be somewhere in the first 2 weeks of June, I think is when we're going to send that out. The 90-day claim filing period begins when that notice is mailed. In September, that's when that 90-day claim filing period will conclude, and the state engineer will begin investigating their water rights. In December of 2017, we'll hopefully publish the list of unclaimed rights. You'll have that 90-day objection window will begin, and we'll hold a public meeting to kind of go over the same thing. Those are rarely very well attended, but we still hold the public meetings we're statutorily obligated to. In March, that 90-day objection period for the list of unclaimed rights will expire. This is obviously 2018. July of 2018 is when we hope to publish the proposed determination, and then you have another public meeting. The 90-day objection period begins again, and then it concludes again in October of 2018. Now, that July deadline for the publication of the proposed determination, that's just kind of that's a ballpark. It depends on how many objections or what other type of things kind of get mired in the works, or how complicated these water rights are to evaluate. But we expect that should be a feasible deadline. Will I lose my water right? So water users who are currently using their water rights in conformance with the records on file with the Division of Water Rights have really nothing to worry about. Okay, we're not out. We don't get any joy out of recommending rights to be disallowed or seeing rights abandoned in the list of unclaimed rights. We just want to make sure that we have an accurate tally of what water rights are still being used. Those individuals who are using water without a water right of record are required to submit a claim and otherwise risk being barred from doing so in the future. Kind of already discussed that. And again, that if water has not been used for a 7-year period or more, the water right or even a portion of the water right may be subject to forfeiture. We call that being disallowed in the proposed determination. So if you have a water right for 10 acres, but you're only irrigating 5 acres, and it's been that way for 7 years or more, we'll come in and we'll say, well, 5 of those acres have reverted back to the public for appropriation or satisfaction of next rights. Who can I contact? That's me at the top. Gary Brimley is my adjudication engineer there in the middle, and Mike Handy is going to be our adjudication team leader. He's going to be the guy directing the boots on the ground, doing the evaluation. Again, this whole presentation is available online, or I'll make it available on our website tomorrow morning. I'll put it there, as well as you can view it on YouTube as well. So with that, I'm happy to entertain any questions. Yes, sir. So what we're talking about, so his question is there any risk of being denied the ability to harvest rainwater is really what we're talking about as a part of this. That's a separate process. The state of Utah allows rainwater harvesting. There are some limits and some requirements. One of the requirements is you simply register with the state engineer. And I think it doesn't cost anything. You just do it online, and it's Roger got it. And then there's some volume limitations, I think, associated with the containers that you can fill. But this has nothing to do with rainwater harvesting. You're still permitted to do so. Yes, ma'am. How do you know if you even have a claim? So this is a question we get a lot, believe it or not. And the answer is you would probably know because you would probably be using it, right? And so you would probably have a well in your backyard that you might be using to irrigate a garden with. A lot of time in kind of in this area, wells preceded the development of a culinary supply. And so often people would drill wells, and then along comes Salt Lake Public Utilities, finally run service to them, and they connect to the public water and get rid of their well, or only use their well to irrigate. So most likely, people who have a water right generally know they do or have a claim. and that means they've been diverting off of a head gate or they've been pulling it out of a well. I mean, those are pretty big indicators, So it's not, that doesn't mean there wasn't a water right associated with your property prior to you knowing about it. But the fact is that if you don't know about it and you haven't used it for 7 years, it may be moot. You may be subject to forfeiture. Yes, ma'am.
I've heard from other cities that a company called Nestle has been coming in, rounding up the water and selling it back to the municipality. I realize that my question is not directly related,
Sure.
but it's probably the main reason I showed up because I don't want Nestle touching my water.
Fair enough.
Do you have any information about the risk of that in Utah or Salt Lake City?
I don't really can speak for Nestle. So her question is, I understand, right? I'm just joking. So her question was, or her concern is that in other areas of the world, in other areas in the United States, certain water companies such as Nestle and there's some other ones have come in, bought the groundwater and then sold it back to the municipality. I'm not aware of any type of scheme like that occurring. You can imagine that Salt Lake Public Utilities would be very opposed to that, and they're kind of the 900-pound gorilla in this neck of the woods. So I'm not super concerned because they own all the senior rights anyway. So I don't see that being a problem. I think where that's mostly been a problem in areas where you don't have the prior appropriation doctrine. So areas east of the Mississippi where they didn't have a system of water rights because, hey, they got plenty of water, right? And they were just pulling water out of groundwater, and they're just irrigating. They didn't need irrigating because they have rain. I think you see that happening more so in those types of areas rather than around. And I'm not familiar with anywhere in Utah where that's occurred. Oh, my pleasure. Yes, sir.
When your people come and inspect now, do you do that by appointment? For instance, ours is in an enclosed building.
Sure. Yeah, so his question is, when our people come out to evaluate water users' claims, do we do so by appointment? Absolutely. We try to. Sometimes people don't want us to come out and investigate it, so sometimes we're just left to just go and do it. But what we encourage you to do is when you file your claim, to put a good phone number and email address on it so that we can get a hold of you and schedule that appointment in advance, because it's really easier for us to evaluate it with the water users there, because then they can show, this is what I'm using it on, this is how this works, and then it's no problem. Yes, ma'am. So her question is kind of prefaced with that she's been drilling illegal wells all over the place. So she's asking, what's the cutoff? What do we need to have before we say we need a water right? Well, the answer is, if you drill a well, you've got to go through the state engineer's office. It doesn't matter if you're not even using water. The state engineer regulates well drilling. And so to answer your question, if you're going to drill a well and you're going to use water, you need a water right. So I would encourage you to acquire those water rights, especially for culinary. Yes, even for culinary. Now, other states, sometimes that's not the case. Like Nevada, they don't require that. But in Utah, if you drill a well, if you put water to beneficial use, you need a water right. So I'd encourage you to square that away. Yes, sir.
So I have a property that has a couple of springs on it, and for years I just used it for the garden and for drinking. So if I file a claim to continue to do that, if I don't file a claim, then could the state tell me that I can't use it for those things?
So his question is, he has some springs on his property. He's been using it to irrigate and maybe even take some drinking water out of it. And he's asking, do I file a claim? And if I don't file a claim, is the state going to tell me to not do it? So let me answer this this way. If there's any chance that this use was being pursued prior to 1903, either way, I would file a claim. The worst that can happen is that we disallow your claim and you're doing the same thing you were doing before, which is using this water illegally. But I can tell you right now, no one's going to fast rope in on your house and assault it. And, there's not any SWAT teams or anything like that involved. So I understand there's this perception of the heavy hand of the government, but really what's going to end up happening is if we evaluate the claim and we can't determine that it's pre-statutory authorized or you don't have a water right for it, we simply disallow it and then we drive on. What that does is, though, you're at risk because if your neighbor or someone doesn't like you, then they can call an enforcement action, but we don't really pursue those. Our team does not pursue enforcement actions. Let's go back here, this gentleman behind the column. We haven't gotten to Parley's yet. So his question is, I'm a flood irrigation user out of Parley's Canyon, Parley's Creek, and it sounds like this is a separate issue. The fact of the matter is we haven't made our way down to Parley's yet, but we're getting there. So, but in this subdivision, it doesn't sound as though the diversion that you're referring to would be caught up in this particular adjudication. Let me get this lady in the back, then I'll come to you. Yes, ma'am. Did you have? Mm-hmm. So her question was that there's some in her subdivision, some of the houses are built in the 20s, and I'm saying that. So help me out. What was the part of the question? What was the question? Sure, but what was the question? So what we're talking about is maybe two separate things. So if you have a house and it's built in 1922 and it appears that it was connected to a well because there was no other water service, then that's pretty good evidence that there's a pre-statutory right associated with that water use. Now, if it hasn't been used since 1922 or 1950 or 1980 or 1990, you're going to have a problem, or there's going to be a challenge. It's going to be really difficult to substantiate the beneficial use with that right. But what I recommend is file a claim. We'll figure it out, and we'll work with you. You know, like I said, we're not out to get everyone's water rights. We want to make sure that they're recognized and quantified. You know, it does us no good if we turn a blind eye or try to forfeit people's water rights. Ma'am, did you have a question? So you're talking about like a deed or if you're selling your house, and I forget what the waiver is or the piece of paper. It's been a while since I've sold my house, but she's asking about, you know, when you're selling your house, you're buying property, often you check a box and you've been advised of your water rights or any shares. That's when you bought the house. Yeah, that's pretty boilerplate, and because the thing about water rights is they transfer via appurtenance unless the deed explicitly states otherwise. So if you have a well and it's irrigating the yard and you buy that house, the water right comes with the property unless during the transfer they explicitly withhold the water right in their name or convey it to someone else. So that's the reason why they want to make sure that you're tracking the water rights issues, to make sure that if you're assuming that a water right comes with that property, that you make sure that there's no explicit language in the deed that says otherwise. And so for the most part, that's pretty boilerplate. To answer your questions succinctly. Yes, sir.
Back to the Parley's Canyon water users situation. Although our property is within the boundaries of the Dry Creek, we get irrigation water from the Parley.
Okay.
So there's this overlap.
There is an overlap, you're right.
So in essence, do I claim my water rights in the Dry Creek area, or do I wait till you come to the Parley's Canyon?
It doesn't hurt. So his question is, even though the Parley's diversion is not in this book, so we use. Let me back up a little bit. We use a convention where we adjudicate by point of diversion, right? It just makes it easier. There's nothing sacred about it, but it's just, hey, these points of diversion, we're going to adjudicate these, and we're going to move over here and adjudicate these. And sometimes there's a point of diversion in this other drainage that's being used in this other one, and that happens pretty regularly. In this area, maybe not as much, but when there's irrigation companies or something like that, you have shares in irrigation, it happens. what I would suggest, just to make sure we got on the radar, it's always helpful if you file a claim, and then you know what? If you filed a claim, then you're good to go. And then when we come down to the parleys, you've already met that statutory claim requirement, and you don't even have to worry about filing it within the prescribed time frame. So what I say is, file early, file often, right? You can't be, and we'll figure it out. All right. Any other questions? Let's go back here and then. So our question is it beneficial use if it's underground water, but it's been keeping the trees alive? For a water right to exist, you have to have diverted it. So underground water doesn't meet that criteria, right? You're not diverting it and applying it to a beneficial use. So although obviously the tree is beneficially using that water, there's no particular water right associated with that tree. So our question is, what if an entire area that wasn't watering was, I'm sorry, you lost me on that one. Do you want to give us some time? Maybe we can talk offline and I can walk you through. I mean, it's, the end of the day is generally you need a point of diversion for it to be considered a water right. There's some exceptions to that rule, but for the most part, subterranean flow of groundwater is not considered an in situ water right. But we can talk a little bit offline, and maybe I didn't answer your question, or maybe you have a different scenario you're trying to paint. Is that all right? Yeah, come on, we can talk that through. Yes, ma'am. Mm-hmm. So, it's approaching zero very quickly the longer on this question goes, but yes. Let me repeat the question just for the benefit of. So the question is that what is the likelihood that that we may have a claim? She presented this example about a brewery that existed adjacent to her property. And she's wondering, what's the likelihood that they would be able to file a claim? As well as she kind of made a more of a commentary on the social injustice occurring here, that because she didn't know about the fact that she had to file a claim, she didn't investigate it. So I think that's pretty self-evident that, yeah, if you don't know about it, you can't file a claim, but unfortunately the law doesn't provide that as an excuse against non-use. To answer your other question, rarely, like I said, if you have a water right, or if you have a valid claim, you probably know it because you've been fixing the well, you've been maintaining the head gate, you've been doing stuff to it. You've been, you're probably imagining a little bit, and there's nothing wrong with that. We can give you an imaginary water right, and you can continue to imaginary use it, I guess. So, yes, ma'am. Mm-hmm. Oh, that's a good question. Yeah, so her question is a well or head gate the only means of diverting? No, it's not, but they're the most common. She talked about maybe some subterranean, some drains, and sometimes that we've seen people dig holes and just have a sump, so it's kind of like a shallow well that they've just put a sump in. and I know there's an area, there's an extensive subterranean drain area in this book. I want to say it's Gilmore Park. Is that a thing? Okay. Yeah, that has this big, long, extensive piping system that runs over underneath houses and everything like that. And so those are just collected in spring boxes and then piped. And then I think they appear in water features and ponds and stuff like that. And there's an actual water right for that. So it's not the only thing, but it's the most common. Yes, sir.
So my question is, why now? How often does this happen? How long ago is this, and how long will it be before this happens again?
Sure. His question is, why now? Why is it happening now? How long ago? How long before it happens again? How long ago did it happen before? The answer is, I'm afraid I don't have a very good one. It's just taken this long to get around to this neck of the woods. Back in the 70s and 80s, we did all the west side of the Jordan River, and then we did some areas up near in the Provo River drainage, and we just felt like, well, in urban Salt Lake City, where a lot of these, because what we're seeing is a lot of these wells were drilled and then they're paved over, as urbanization increased. And so the emphasis has been to understand what water is being used, and is in order for Utah and especially Salt Lake Valley to anticipate and plan for the future. And so when I first came to this job back in 2011, we started adjudicating on the east side of the Jordan River, and we've kind of been just taking bite-sized pieces, and the governor and the state legislature has given us some funds to kind of help expedite this. So hopefully it won't take another 80 years until we get done with this, but we're trying to move forward. So the answer is it won't happen again. It's not intended to happen again. It's kind of a once and done and really the reason is we want to capture all these pre-statutory rights, bring them on record, and then carry on and try to find all the other ones. Well, let me get this lady. Yes, ma'am. Certainly. So her question is, she restated the fact that we can have someone in my office help them prepare the claim, and when can we make an appointment? Mike Handy, why don't you stand up? So Mike is the team leader. Feel free to make an appointment with him anytime you'd like. And you have his contact information right here. He's going to be the guy, or one of his team is going to be the guy that's going to be helping you prepare those claims, or someone else. But, you can walk in, but we really prefer if you schedule an appointment just so that we know we have someone conversant in the area who can help you prepare an adequate claim. Otherwise, you never know who you may get. You may get me, and you don't want that. You want one of these guys doing it. So, all right. Yes, ma'am. So our question is that, these 34 claims, or the water rights of record is what they are, are they published anywhere? Yeah, and I can show you on the website where you can go to our website and have an aerial imagery interface, and you select the little feature that says points of diversion, and it'll show all these little points, and you can say, all right, that looks like that's on my property. And that's really what we do when you come in and say, I think I have a water right. We'll go and we'll pull that up and say, well, it looks like there's a water right nearby, and is this the previous property owner? So there is a way to access that, and maybe following this question answer period, I can just demonstrate it on the big screens for everyone. Yes, ma'am.
So if you haven't used it for 7 years, it's automatic default, right?
So our question is, if I haven't used it for 7 years, is automatically gonzo, right? The answer is yes, but I'm always going to caveat. It's like, if we come out and evaluate that water right and the well appears to be working, we're not going to go CSI water rights and inspect 7 years worth of aerial imagery to see if it still had been used. We're going to say, yep, looks like you got beneficial use. Thanks for your time. So that's kind of the hint, is like, stomp your foot, make sure it's being beneficially used when we come out to evaluate it. Put it back to beneficial use. If it hasn't been being beneficially used, let's preserve your water rights. Let's make sure that this doesn't fall. It doesn't mean create an imaginary water right. It means, if you have something that's there and it's just falling into disrepair, now's a good time to start looking into getting that fixed.
Well, if it's beyond 7 years, okay, do I have to
But-
it's automatic default, but do I have to do anything more?
So she's asking, do I have to do anything more if I don't?
Sign off my property
No, I mean, honestly, if you don't do anything and there's a water right of record, it goes on that list of unclaimed rights and gets decreed as abandoned. So by doing nothing, you've in essence said, I'm not doing anything with this. This water right can be abandoned. So you don't have to sign off anything. Usually people are anxious to preserve those. But if you haven't used it in 7 years, again, if we come out and it's being used, we're not going to interrogate you with a rubber hose and a flashlight or anything like that. We're just going to say, oh, it looks good. All right. Yes, ma'am. It's a good question. So her question is, she purchased some property. How's the jurisdiction interplay between Salt Lake and the state of Utah? State of Utah always trumps, so just push that aside. We got that argument resolved. But really, so you say the state in Salt Lake said after 2 years of non-use, it's forfeited. So we want to be clear what we're talking about. There's water rights, which are what I'm talking about, and there's shares in an irrigation company. And shares in an irrigation company have their own company bylaws associated with them. And some of those bylaws may specify, hey, if you don't use your shares within 2 years, those shares get spread amongst the other shareholders. So I'm not sure. So either you're getting bad information, someone at Salt Lake is being very crafty and trying to get you to believe that you don't have a water right, or they're informing you about this share and these bylaws in that company that maybe those shares are no longer applicable. But the statute is 7 years. Regardless of what Salt Lake City says, it's 7 years. Yes, sir. So this question is, how do you establish a non-existent water right? And really what you're asking is, how do you appropriate a new water right in the basin? And whether that's to cover down on your use that you're using that doesn't have a water right or whatever, right? In Salt Lake City, the basin is closed to new appropriation. So the only way to acquire a water right is to purchase one from someone else and then file what we call a change application, which moves that diversion from where that water right was used previously to where you intend on using it afterwards. So you can still do it, you just have to acquire it from someone else. And there's a website, I think it's waterrightsexchange.com or something, where they broker in these things. It's like KSL.com, or you can go to KSL.com as well, with classifieds. You can find water rights there as well. So there's a market out there. A little bit of you might get some sticker shock. Just you can prepare you right now for Salt Lake City water rights. So. Yes, ma'am. So her question is, did I say that we were going to send a notice when you can come and apply for water rights? Let me say we are going to send a notice, but the notice is for you to file your claim. If you want a new water right, then that's a different process. But if you have an existing well or an assertion of a claim, you'll receive this notice and be given instructions. Now, you can come before then, and we'll help you out. But you'll receive this notice in next couple weeks. So yes, I did say we are going to send notice. And yeah, there's always someone here, and so there will be contact information. You can come in to the front lobby here, say I'm here to see the Division of Water Rights. They'll send you up, and our front lobby will take care of you. So it's just better if you if you schedule an appointment, just so that we have someone ready and knows that you're going to be here and doesn't go off to lunch or something like that. Hold on, this gentleman had a question, really, and I'll get back to you.
I was just going to say to her that if she calls my handy, they'll send her the application, whatever that she needs.
Yeah, call Mike Handy. Handy Mike Handy.
I'm confused. You're talking about 8,400 people got a notice, and you're talking about 34 people have got water rights.
Mm-hmm.
Are all 8,400 going to get the notice
So his question is he's confused because you have this disparity between the 34 owner water rights of record and then the 8,500 people that we sent notice to. And he's asking, well, who are you going to send notice out? And the answer is both. So all 8,500 plus 34 and change, right? They'll receive notice to file a claim. The property owners, which are the bulk of the 8,500, will receive the notice with a blank water user's claim. And so that's going to take a little bit of figuring out because there's some questions unless you really know what you're talking about with the public land survey system or how to quantify water or acreage that are going to be challenging. But if you come in here, we have all the tools. We can draw on a map. We can figure out your acreage. You can figure out all stuff. So I'd encourage you to come in. Now, the water right owners of record, we're going to send them what we think their claim should look like based on their existing right. And then they can modify that, line it out, and sign it. Okay? Yes, ma'am. So sometimes this urbanization has kind of grown over top of existing irrigation ditches. So I do know there's some areas where the water running down the road is actually irrigation water that they do put a head gate in and they do kick it off into their yards. But there's also just curb and gutter, right? And it's just storm water running down. Yeah, so it sounds like that's probably some shares or some type of irrigation system that's been established from what you're describing. No, it's part of the system. So, yeah. So, whoever the owners of the water rights for that system would be required to file a claim. Now, if it's a system and it's like an irrigation company, the irrigation company are the owners of the rights. They would be required to file a claim. But it doesn't hurt for shareholders to just file a claim just to kind of get heads up that, hey, our company, our irrigation company leadership, they're lazy. They don't want to file a claim, so I'm going to file a claim on their behalf just to make sure this water right gets preserved. So that's why I say file often, file soon, file frequently, whatever. Just file. Well, the private company might own the water rights, but they still report to us. So it's like the private company is like a person. You remember how the Supreme Court says a company is a person? It's just the same deal, right? They own the water rights. And so they're the responsible entity for filing the water user's claim, but they file it with us. So even though they're a company, it's just kind of a different mechanism of how to share water amongst other people. Is that the company owns the water rights and they issue shares of that water to shareholders who then use that. So little different, but ultimately still applicable to what we're discussing. So our question is, if that water running down the street 20 feet from house, can I figure that out and acquire shares? Probably. How would you do that? Boy, I have no idea. So it sounds like this is a system managed by Salt Lake Public Utilities. Yeah. And that may be the same issue that the other lady was talking about with regard to the 2 years of forfeiture type of thing. So yeah, so I would and Salt Lake City is very aware of what's going on here. So if there's a claim to be filed, they are on top of it. I promise you that. We have too many meetings with them already. Yes? So our question is, if a person sells a property and they have water rights, do the water rights go with the property? The answer is, it depends. Most often, yes, water rights are considered appurtenant to the property that they're on. And so if they convey with the deed, unless the person who owns the water rights and the property explicitly withholds them during the conveyance. So if they say, I am selling you this property, this many acres, accepting all water rights or accepting this water right, you are now the holder. Yes, you can That's right. One can keep a water right, can prevent it from transferring by appurtenance. For the most part, they transfer by appurtenance, and anyone who's buying property would want to make sure that they acquire the water rights associated with. Boyd. Yeah, that's a good point. And so he just highlighted the reason why we send notice to everyone, not just water right owners of record. Because we understand that these conveyances can get murky over time, and we want to make sure everyone has a chance to bring their claim forward. Is that all the questions? One more. Grand Street Canal? I am not sure. I have no understanding of that. We can look at it. Oh, he's asking if there's any chance of tapping the Grand Street Canal, and I'll be quite frank, I have no idea. It's probably, if I were to be a betting man, I'd bet it's owned by Salt Lake Public Utilities, but I'm not sure. Maybe someone else who's more familiar with that area can speak to that. But all right, I'm going to go and I'm going to hook to the internet and then kind of do a quick navigation to our website and show you how you can access the aerial imagery and the maps and stuff like that for those who are interested. For those of you not interested, we do have some maps on the table out there and some staff who can walk and talk through some of those issues. But let me try to do this. Let me connect to the internet here really quick and